Hi, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And today we are going to continue our video series designed to educate and inform the public. So please reach out and subscribe to our channel. Today I want to talk about modifying your judgment of divorce. A lot of people go to court. They can't settle their dispute, so they have a trial. And during the trial, you're calling evidence, the other side is calling evidence. You're cross-examining witnesses, you're bringing in exhibits, they're bringing in exhibits, and ultimately the court makes a ruling. The expectation of the court is whatever is relevant, whatever is necessary to help the court make the ruling, you brought that in. That case is there. Now the court has everything in front of it, and ultimately it uses all those tools that you provided, and it constructs a verdict, a ruling, a direction where the case should go that ultimately finds its way into a judgment of divorce. And you're not happy. You don't like the judgment. You don't like the way it came out. You don't like the parenting time schedule. You don't like the evaluation of the business. You don't like this, you don't like that. What do you do about it? Is it a good idea to file something immediately? To ask the court to modify it immediately? Or should you wait a little bit? And I would tell you this. If you're talking about actually appealing the judgment, you don't have the option of waiting too long. From the time that the judgment of divorce is entered, you have a limited amount of days to file that claim of appeal. So in that analysis, if we're talking about appealing the judgment, you don't have a lot of choice. You don't have the luxury of waiting till you're good and ready. The court rules dictate how quickly that has to be done. And under what circumstances something can even be appealed. You just can't appeal because you don't like what the judge said. The judge has certain discretion that the Court of Appeals is never going to change. The Court of Appeals, for example, is going to give the lower court great deference to how the court judged credibility, for example. If somebody testifies and the court finds that person to lacking credibility, it's not likely that the Court of Appeals is going to say, well, we weren't there, but we're changing this ruling anyway. We're going to find this witness credible, even though the one who was there and could witness it did it. So no, that's not going to happen. So appeals are different. Let's say you're talking about modifying something. Let's say the court said, okay, for parenting time, we're going to do alternating weekends. We're going to see how that works. If you don't like that, because you feel it's not good for the child, it's too much back and forth, it's never how you did it before, whatever your problem may be, and you want to bring it to the court's attention, you want to modify that, I would tell you this. The court spends hours reviewing testimony documents. In most cases, will really work hard to come up with something based on the evidence, based on what it thinks is in everybody's best interest. When you're coming before the court and asking that it be modified, what you're really saying to the judge is, I heard what you said, I know what you did, I don't like it, I want you to change it, we don't think you did this correctly. Well, you know what? The court is not apt to say, oh, you're probably right and you're changing it when the ink is barely dry on the judgment. Court's not apt to do that. However, if you tried it and the circumstances have changed, or the assumptions that the judgment was based on are just not working out like you thought. The court expected that dad would come and be picking up the kids every other day from work and bringing them this, and it was good, and he hasn't done that. His schedule is such that that can't work. It's not practical. What's practical then? What's practical now? Well, so then once you have that, the court will say, okay, we've tried it. I've had the judgment. It's been a couple months, and the parties have made best efforts. It doesn't work. Then the court might consider making a modification. If you ask for that modification immediately, it is likely that the court's going to say, you know what, you didn't even give it a chance. So unless there's some huge mistake that the judgment embodies, generally speaking, it's a better practice to give it time, wait a little, and even though you may be hot to trot on getting it modified, an experienced attorney will tell you, hang on a minute, this thing's brand new. While you may be right, the court is probably not going to hear that. And if you file it now, and the court denies you, so you wait a month and file it again, the court already has in mind that you filed it too early, that they denied you the first time, and by simple inertia, they may deny you again. So there's a strategy in waiting the right amount of time, depending on what you want modified, in order to approach the court and get the answer that you want to get. That strategy is something best understood by your lawyer rather than yourself. So take the opportunity to consult with your lawyer and get some guidance on that. If you have any questions about your case, reach out, and we'll be glad to help you out.